We're good to go. Have you got the screen working?
Yes, thank you very much.
Court rise if able.
Yes, Mr.
Good morning, my lord. My lord, I appear on behalf of the appellants in this case, the first and second defendants. Mr. Bruce Walker appears on behalf of the claimant, who is the active respondent. My lord, in terms of the housekeeping issues, the court should have core bundle, supplemental bundle 1 and supplemental bundle 2.
Yes, thank you.
And also a joint authorities bundle.
We do.
My lord, in relation to housekeeping on the authorities, just one matter I'd like to raise, which is when I filed the authorities bundle, I hadn't appreciated there was any issue between Mr. Walker and myself as to the precise extent of the principle that was established in Re White and Drake and Harvey, and then set out in Ham and Ham. But I think there is a one element of issue between us on that. So having spoken to Mr. Walker subsequently, I think it may be necessary for us to refer to those two cases, which aren't to avoid proliferation of authorities in the bundle.
Fine. So where do they exist at the moment?
So I brought paper copies along, my lord, which I can hand up.
Yes, if you do kind enough to do that, thank you. Yes.
My lord, in terms of the nub of this appeal, obviously you've seen the respective skeleton argument. I think really if one turns to the second judgment of the trial judge,
Thank you.
in the core bundle at page 134, those are the passages which lie at the heart of, first of all, what was common ground at trial, and was common ground on appeal, and where the parties part company. And there are really 4 points there. The first point in paragraph 223 is that it was common ground and found by the judge that ultimately all of the partners had agreed to the claimant retiring from the partnership and ceasing to be a partner as from 8th of July 2010.
Yes.
So that was common ground. It was common ground also, if one looks at paragraph 226, that with effect from that date, by agreement, the partnership had continued, or a partnership had continued between father and the two brothers, my clients, and that had taken on the assets and the liabilities of the partnership, which had previously included the claimant as at 8th of July 2010. So all of the assets and liabilities as at 8th of July 2010 had passed to the continuing partnership between father and the brothers. That was common ground and found by the judge. And it was also common ground and held by the judge that the claimant was not responsible for partnership debts incurred after that date. So those are the key matters which were common ground and accordingly held by the judge. The issue which was not common ground and which is central to this appeal is paragraph 227. And in fact, on this appeal, the first half of paragraph 227, key question is what, if any, recompense the claimant was entitled to from the continuing partners. My lord, I will...
Say under 226, she wasn't responsible for partnership debts. One could have included profits if there had been any. It wasn't common ground, but we're concerned that the bar dropped in 2010.
Yes.
So we're not arguing about what happened after that.
No.
It's what legal situation crystallised at that point.
Yes.
Yes. So you're now on 227.
Yeah, so 227. Yeah, so 227, really the key question on this appeal is the first half of that sentence. What, if any, recompense the claimant was entitled to from the continuing partners? The sentence goes on to say, or liability she was under to the continuing partners, but that was dealt with by agreement, so it's no longer live. And I will go through in more detail shortly the evolution of the claimant's claim, but you will have seen that it is a claim to 1/4 of the value of the Agricultural Holdings Act tenancy, which was declared to exist by this court, including my Lord Justice Lord Nugee, in 2001. And the claimant claims that she is entitled to 1/4 of its market value as at the date from which she retired from the partnership by agreement. And in essence, the evolution of her claim, as we'll see in more detail shortly, is in the original pleadings prior to the first trial in 2018, the claimant's case was focused on denying that she was liable to pay off her negative capital account balance as at the date of her retirement. We then had the 2018 trial, the 2019 judgment, the appeal to this court, which was held in 2001.
21.
Yes, sorry, 2021. And the judge then ordered there be further points of claim, points of defence and points of reply in relation to the remaining issues which had been held over or consequential on the Court of Appeal judgment. And as I'll show you in a moment, the claimant's case in that was that the agreement to retire, although it had been a retirement by agreement, she claimed that its legal effect as a matter of law was a dissolution, and that consequently, because it was a dissolution, she was entitled to 1/4 of the value of all partnership assets as at the date of agreed retirement, including the tenancy. Now, following the judge's judgment, where the judge said he didn't necessarily need to go into the jurisprudential basis for his decision, but that it appeared to him to be based on implied terms, on this appeal, the respondent, as well as maintaining their original case based on the retirement by agreement being a dissolution as a matter of law, are also seeking to uphold the judge's reasoning that it's appropriate to imply a term. And the way my learned friend puts that in his skeleton is to say that a term should be implied into the 1980 partnership agreement, entitling any partner who retires voluntarily to be paid out on a full valuation of the net assets minus net liabilities. So essentially on this appeal, she has two main contentions in that regard. And in terms of a brief roadmap for my submissions, I intend to, subject to the court's preferences, start by just outlining some of the more key aspects of the factual background for the purposes of this appeal. Then secondly, dealing with, in a little more detail by reference to the documents, the evolution of the way that the claimant has put her claim. Thirdly, the legal frame.
I'm just pausing on that. What's it matter how anybody's put their claim? And this is it's not suggested that the judge's decision was, as it were, out with the arguments that were put to him. And so far as I understand it, what anybody says about the legal rights, or indeed whether anybody's deserving or undeserving, is neither here nor there. It's really a matter of law, isn't it? What the
it is, my lord.
The parties' rights were in 2010.
Yes, it is, my lord. And if it's not going to be helpful,
No, but I'm just saying. I mean, I quite understand that as a point of comment, if you say that from your client's point of view, the respondent has gained a windfall that she was arguing against at a previous stage in litigation. I mean, this is terrible litigation. It's been going on for a long time, and people have been arguing arguments that seem to them advantageous. Nobody seems to be able to rise above this and work out where it's all going. So I'm not sure we're going to get any help from the fact that people have been turning around in circles, arguing this, that.
Well, my lord, just I can perhaps pick up on it then more briefly. But the reason
I'm not trying to stop you, but
no,
you know, as a you know, if this was a different sort of court, those sort of points might hit home. I'm not sure they can really.
Well, my lord, just to say briefly, the reason why I thought it might be of assistance, but I won't otherwise go through it, is that my learned friend says, in relation to his implied terms point, that the provision he's contending for is so obvious as to go without saying, or necessary for business efficacy. And I do say it's of some relevance that the point wasn't raised at any point prior to effectively the judgment.
Well, I mean, but anyhow, both parties can be assured that we're not going to be influenced what any of these three think.
Yes.
It's what they, if what they agreed or what they can be taken to have agreed is another matter.
Yeah. My lord, then, if I turn to the sorry,
you were on a good
I've gone off route on my roadmap.
Please go back to it.
I was then going to deal with the law as a matter of principle and then the application of the law to the factual framework. My lord, then, if I start with the factual framework,
yes.
I think the court will already have seen the general nature of the background of this dispute. So I don't think I need to go through in any detail the factual situation.
We have the history very well in mind, but please pick out any particular points that you lay emphasis on.
Yes. So in terms of just a few key points for the purposes of this appeal, you'll have seen that the land in question is an agricultural set of land that was built up mainly by the party's grandfather around the middle of the last century, was added to by father and mother. The farming is essentially arable farming that was carried on by father alone prior to 1980, but since 1980 through the vehicle of the partnership. And you will have seen that from the early 1990s there was farm diversification in the form of the golf course, which, although it was hoped that that would be a useful form of farm diversification, in fact, as you will see from the accounts, along was loss-making. In terms of the individuals concerned, father was in poor health for most of his life, and as is set out in the judgments, was also very focused through his life on avoiding lawfully, wherever he could, paying unnecessary taxes, in particular capital taxes. That was a very strong theme through his life. And he was also a strong personality, and one can see from the judge's comments the relevance of that to how the parties behaved in relation to him. And the reason why the land ownership and structures are so complicated is to a large extent driven by father's desire to avoid lawfully paying tax where possible. The father and mother lived on the land until their deaths. The first and second defendants, my clients, having both gone away for periods of time, came back to live on the farm. And the first defendant in particular was actively involved in the management of the farming business and the golf club business. The claimant, having moved to London, had a career in the City of London and wasn't actively involved in the day-to-day work of those businesses, although obviously she was a partner in the partnership. Then to pick up a few specific factual matters of relevant background to the partnership. Just in relation to the claimant's own case as to how she saw the partnership at the time of the relevant events that we're looking at. In Supplemental Bundle 2, page 167, is the claimant's original our amended version of the reply prior to the first trial. Should be paragraph 18.3 of that.
What date is this?
In its amended form, it is August 2017.
When were the proceedings issued?
They were issued at the end of 2016.
Thank you.
Sorry, can you give me the page number again?
I'm sorry, it's page 167 of supplemental bundle 2.
Do we have the claim form or the original?
The claim form is that unfortunately the pleadings at the beginning of this bundle are in they're in date order, but because of the amendments, they're not in a particularly logical order. But the claim form is behind tab 2 at page 160.
And the primary relief sought in the first place was the removal of your client as a trustee, was it not?
That was a major element of the relief sought, yes, my lord. But there were also declarations sought in relation to the partnership. So there were negative declarations, first of all, that the claimant wasn't liable to pay her negative capital balance, and also a declaration sought that father, on his death, his negative capital balance had accrued to my clients rather than remaining with father's estate. And then there were various other declarations sought about various disputed debts and such like.
Thank you.
And then obviously also the issue of the Agricultural Holdings Act tenancy. So going back to page 167 in that bundle, this is the claimant's amended reply prior to the first trial. And 6 lines down, one can see that she said there, the family has always viewed the land at Skelton as morally belonging to father and mother and subject to their direction. And this has been the case whether it was technically held in their names or held by the trusts. Similarly, the farm business and the golf course business, which were of course run by the partnership, were viewed as effectively being father and mothers. As such, father and mother called the shots in relation to the land and family businesses, and the siblings were expected to fall in line. The partnership existed, but the reality of the situation was that it was a convenient vehicle for running the businesses and keeping accounts. As such, it was viewed primarily as a mechanism only, and it was not intended to infringe on father and mother's ability to run the businesses or call on funds during their lifetime. And then she goes on to deal with issues about the disputed tenancy. And then the last sentence of that paragraph, it was never intended that any family members would be acquiring legally enforceable rights against each other. So that was her case in relation to that. The judge then, in his findings in the his first judgment after the 2018 trial, that judgment starts at page 311. But if I could ask you to turn please to page 336. Rather than me reading it out, could I just invite you to read?
Sorry, you're going into what, the first judgment?
This is the first judgment after the
I'm just
2018
puzzled
trial.
by, so you're referring to internal pagination, are you?
It should be the pagination of.
I think the problem is that electronically the bundle's been split into 2.
Right, I've now got that. Thank you.
Which paragraph?
Paragraph?
well, paragraphs 92, 93 and 95, please. If I could just invite you to read those.
Yes.
So, my lord, that gives a flavour both of the, well, that sets out first of all the judge's findings as to the legal position, but also a flavour of the family dynamics in relation to the partnership. My lord, then if I could take you to, in the same judgment, page 341. If I could just invite you to read, please, paragraphs 112 to 115.
Yes.
So, my lord, that again gives the flavour of at least how father saw the partnership and his reasons for having set it up in the first place. My lord, then turning to the judgment which is under appeal, which is in the court. Just a couple of points in relation to the judge's findings and commentary in relation to the accounts of the partnership around the relevant time. Paragraph 101, which is on page 101. So this sets out how, when the golf course was built in the early 1990s, how the cost of building it was dealt with in the accounts. And one can see that, as the judge set out, the expenditure regarding the construction of the golf course was capitalised in the balance sheet as fixed assets, as the various items of expenditure were spent on building it. And one can see that in the notes also on the accounts by the accountant on the next page, page 102. All workings in land, to include those relating to the construction, improvement and operation of the golf course, have been carried out and paid for by the partnership, the occupier, with the consent of the landowner. The partnership is entitled to the full value and or benefit of such works, which are therefore shown in the accounts as assets of the partnership. So, in relation to the way that the accounts operated, as is common ground, they didn't seek to put in an accurate statement of what the assets were or what their value was, but rather to put in assets as items per their cost, whether or not that would actually be related to their value, and also not seeking to have every asset in the partnership accounts. And then in relation to how the capital accounts were dealt with, page 133, paragraph 219. If I could just invite you to read that paragraph, please.
Yes.
So in the accounts, the capital accounts were not proceeding on the basis of capital as properly so called as envisaged by the Partnership Act, but were effectively a balance sheet of net assets, net liabilities at book values as shown in the accounts.
But they were effectively the balancing item against the book values.
Yes, so it was a balance of the assets of the partnership at book values.
And
And
presumably that's why Susie ended up with a negative entry because there were losses.
Yes, my lady, I'll take you to the accounts in due course, but essentially the golf course business was significantly loss-making and offsetting any farming profits. And there were large loans, debts to banks, both overdraft and a longer term loan. So that's why the capital accounts were effectively negative and becoming increasingly negative.
What do you understand the judge to refer to when he says the capital accounts were not therefore the usual form of capital account that is traditional in the context of a partnership?
Well, my lord, based on my experience, it might have been better to have said the proper form as envisaged by the Partnership Act,
Yes.
on the basis that lots of partnerships seem to treat capital in this way, as opposed to the...
What would you say the proper Partnership Act form of capital accounts should be?
Well, the capital there should be what the partners have introduced to be risked in the firm.
The cash or cash equivalent that each partner brings into the firm.
Exactly, and so that should be then a fixed sum, whether it's brought in as cash or whether it's brought in as assets which you can put a value on.
Well, a fixed sum, but liable to adjustment for drawings against capital or accretions to capital.
Yeah.
Profits are sometimes capitalised.
Yes.
And so on.
Sorry. Yes, I meant a fixed sum as in the thing which has been brought in is a fixed sum, but as my lord says, that can be added to or reduced.
Yes.
By drawings or further inputs of capital. But what the capital shouldn't be is, or at least should not be as envisaged by the Partnership Act, shouldn't be a book balance each year of assets versus liabilities. But that is very commonly done in my experience.
Yes, but neither way of drawing up capital accounts, neither what you call the proper way of doing it or this way of doing it, is intended to reflect actual asset values. They're intended to reflect either the amount of cash brought in or, on this way of doing it, a figure, a balancing figure based on historic costs, not asset values.
Yes, neither method shows the current reality of the situation of the real assets of the partnership at their current values and the real liabilities.
Thank you.
If I could then turn to, against that background, as it were, to the partnership agreement itself, which is in supplemental bundle 1 at page 4. The parties have already set out, I think, the principal provisions in the skeleton argument, so I'll deal with this fairly briefly. But it was set up on the 1st of October 1980 between father and mother and their 2 eldest children. James Procter, who was brought in subsequently, who was too young at this stage to be a partner. The first recital recites how Mr. Procter, the father...
Do we have the dates of birth of the siblings?
They are in the first judgment, my lord. I can find those for you.
But I assume that Philip and Suzanne were then, what, in their 20s?
Yes, they were just of majority, as it were.
And is Suzanne misspelt here? Is it with a Z normally? Properly? It seems to be with a Z
It is.
in the
Yes, I don't know
Title.
whether that's because the spelling has changed or whether it is a misspelling.
Yes. Well, we don't want to set any more hairs running.
No. So reciting that the father, Mr. Procter, had been farming on his own account and now wished to bring in the other parties into partnership. Paragraph 1 is the deemed date of the beginning of it. Second is the name. And then the third one, subject to the provisions of dissolution, hereinafter contained, partnership shall continue until determined pursuant to the provisions hereof, notwithstanding the death of any individual partner. So that's an agreement for the purposes of the Partnership Act that there won't be a dissolution on death. Over the page 5, clause 5, provides that the capital of the partnership shall consist of the value of live dead stock machinery and other assets of the father's business heretofore carried on by the father. Mr. Walker says that clause is muddling capital and assets. In my submission, it's not. What it's saying is that the father is introducing as the initial capital his assets. So it's introducing capital properly so called in the form of things rather than cash. Then there are profit shares. Page 6, clause 8 deals with the proper books of account, which provides for annual profit and loss accounts and annual balance sheet, but without going into any further detail about those. And then page 7, clause 14, there's an agreed provision for dissolution in 14.1 on 6 months' notice, and in my submission, it's significant there that that is reserved to the parents, father and mother. Then clause 2, there are provisions for deemed retirement, where there is prejudicial conduct or persistent breach by a partner, or if a partner becomes bankrupt, and if notice is then given. Again, the control for that is in the hands of the senior partners, father and mother. And then 4 is on the death of the partner in question. And then there are deeming provisions in clause 3, 14.3, in relation to the financial entitlement in one of the fault provisions, which is then defined as, for this purpose, partnership share, being the amount standing to the credit of the capital account, amount standing to the credit of the current account, although in fact in this partnership the accounts didn't normally include a current account. And then thirdly, share of the profits through to the relevant period of the accounting year. And the supplemental deed of partnership is over at page 11. I don't think I need to go through any of the provisions of that. It's effectively bringing in the second defendant once he's become old enough on the same terms.
well, it varies the shares.
Sorry, it varies the shares, but those were varied again later as well. So they were varied again after the next event I was going to take you to, which is mother's retirement in 1997, and that can be seen, what happened there, described in the judge's 2022 judgment, the one under appeal, in the core bundle at page 132. If I could just invite you please to read paragraphs 217 and 218 of his judgment, pages 132 to 133. So in other words, what mother received was in line with clause 14.3 of the partnership deed. And then turning to the partnership accounts, in the period that's relevant to the retirement by agreement of the claimant with which we're concerned.
Just a second. Just hold on a second.
You said that the accounts didn't actually include current accounts, but there's a reference in 220 to mother's loan or current account left outstanding.
What happened in relation to her capital account was that she made a drawing of some money, and then the remainder of it was turned into a loan from mother to the partnership.
I see.
So there weren't ordinarily current accounts in the accounts, but
Yes, I see. Thank you.
Sorry, my observation was, I think you said, although I may not by now have got your words exactly, that the mother's situation was dealt with in accordance with 14.3.
Well,
I think what you were really meaning was as if she had fallen within 14.3.
yes, I was not saying that it was
No,
under that clause. Yes, yes,
but it came to the same thing.
Exactly. Yes. Now, in relation to the accounts in the period around before and after the retirement by agreement of the claimant, those are in Supplemental Bundle 1. And there are 3 sets of accounts here ending 5th of April 2009, 5th of April 2010 and 5th of April 2011. And if one starts with the ones ending 5th of April 2009, just to show the court, first of all, how the accounts are structured and also what the financial trend of the partnership was in the lead up to the claimant's resignation. The 2009 accounts begin at page 33 of Supplemental Bundle 1. So one can see on page 34 the partners set out their father and the 3 siblings. Page 37, the profit and loss accounts were split into 2, one for the farm and one for the golf course. Page 37, one can see the farm was making a modest profit there of £57,000 in that year. But over the page 38, one can see that the golf course in that year made a loss of £147,000. So the net loss there was around about £90,000 for that year for the partnership business. And page 39, the balance sheet. One can see it set out in the normal way, but the deficiency of assets, one can see just level with the second hole punch holes, was 495,177. And one can see in the line below that, that is then set out as being financed by the capital accounts. So the net book value deficiency of assets is then made equivalent to the capital accounts each year. And in terms of tangible assets, going back to what I was referring to earlier about things like the expenditure on building the golf course being capitalised as a fixed asset, one can see the accounting policies on page 40. note 1.1, prepared under the historical cost convention, modified when necessary to include the revaluation of certain fixed assets. And then note 1.3, dealing with the approach that's taken to depreciation. And then in terms of the financial position of the partnership, page 42, one can see there in terms of the liabilities, the two single most significant items are under note 5, the first line, the bank overdraft of 174,000 odd. And then note 6, the long-term liabilities, loans £565,000. That is the long-term 20-year loan from NatWest, which is referred to in the correspondence around the time of the agreed retirement. And just to give a further flavour of the direction of the partnership financially at this time, leading up to the agreed retirement, the 2010 accounts, year ended 5th April 2010, are at page 43. Page 47, the farm profit and loss account has made a reduced profit of only £20,000 in that year. And the golf course on page 48 was still losing money heavily, and one can see the loss there made by the golf course that year was £107,000. And the consequence of that for the balance sheet, which was operated in the way we've seen, one can see at page 49. Effectively, the deficiency of assets of the partnership have increased as a result of the further losses, from 495,000 to 583,000 in that year, and that is then distributed by being allocated to the partner's capital accounts. So one can see then the capital accounts, page 52. So father's capital balance was a negative 423,000. The first defendant's negative 55. The claimant's negative 45, and the second defendant negative 59. So that gives a flavour of the deteriorating financial position. Then turning to the facts in relation to the circumstances of the retirement itself. Those are in likewise in supplemental bundle 1. Just to take you briefly to the NatWest loan agreement. That is in supplemental bundle 1 at page 25A. And page 25B, one can see there that it's a loan of the £565,000 for a 20-year term, and clause 1, purpose to be utilised for refinancing existing indebtedness with various loan accounts to the bank, and to repay some existing debt with the Agricultural Mortgage Corporation, and to assist with working capital. And one can see in terms of the date of that, on page 25G, it had been signed on behalf of the bank on the 10th of September 2007. And one can see it was eventually signed on that page by all four partners. But if one turns to page 28, dealing with the position once the bank had offered the loan but before the claimant had signed it. Page 28 is a transcript of father's handwritten letter to the claimant, the 26th of September 2007. As discussed last evening on the phone, the financial state of the partnership is dire. Reasons why that's so do not matter as, at this moment. We have to find a cure pronto. That's the purpose of the new agreement. That's the loan agreement with NatWest. Then he goes on to say he understands why the claimant has reservations about signing that loan agreement, but it's not the time to sort that out.
This is all in the judgment, isn't it?
Yes, my lord.
I mean, we don't need to read it all out
Right.
because we've read it already.
Yes.
By all means, take us to points that you particularly rely upon. But,
Yes, well,
in a sense, what the event is looking at matters which we've already read a summary of
My lord, yes. In that case,
in full, pretty much.
yes, my lord, I will let's go through much more briefly. So paragraph 30, page 31, just to emphasise there, the claimant in that letter was expressing concern about how much she personally was at risk, her personal assets outside the partnership as a result of the indebtedness, and in particular the NatWest loan, and at the end accepted the suggestion that she resign, but didn't at that point. Page
So
100.
the suggestion came from father, did it?
The suggestion came from father. Effectively, he's saying, I can understand why you're worried about signing the loan document. Please sign it, but if you don't want to, then please leave the partnership.
And come back in future if you want.
Yes,
Because we want to get on with it.
yes, because it's vital because of the dire state of the partnership. We need this loan money now, so either sign or let us sign. So anyway, her response to that was to say, yes, that sounds a good idea to leave the partnership, please. But in fact, she ended up signing the NatWest loan agreement and remaining in the partnership at that stage.
Do we know when it was signed? Is there a finding by the judge?
I don't know the precise date when she signed it, but it was shortly after that. Then moving forward to 2010, page 102. In fact, one can see on the previous page 101, this is a handwritten note by the claimant herself, and it's her notes of a telephone conversation which she'd had with Mr. Philip Procter, the first defendant, and draw your particular attention on page 102. SEP, that's the claimant, said, I'm not prepared to put more money into the partnership. I am going to come out of it. Dad has suggested I do this. And Philip's response is, you'll have to have a word with Dad about that. So, as we've seen, the financial state of the partnership was getting ever worse. The claimant did not want to put more money in, wanted to come out, and was referring to father's suggestion in that regard.
Do we have a date for this document?
The date is June 2010. There isn't a precise.
Is that a finding by the judge?
I'm not sure whether the judge actually found it, but that was the date in the chronological run of the correspondence at the trial.
Thank you.
And then at page 54, in the same bundle,
Sorry, give me the page again.
Page 54 in the supplemental bundle 1, my lord. So that is the letter of resignation, which was subsequently treated by everyone and agreed to be an agreed retirement with effect from that date.
Sorry, we're looking at page 55, did you say?
54.
54. Yes, thank you. Sorry, yes.
This suggestion from father that she resigned, this can't be a reference back to what happened in 2007, because she did ultimately sign in 2007, so it must have been a new suggestion in 2010.
Well, my lord, we say that the suggestion was back in 2007, and that effectively she was reviving that and saying he suggested that. We say, in fact, he'd suggested that several years previously, but she was now in 2010 choosing to take it up.
Does the judge make any findings on who's?
I have to just double check that, my lord. I don't think he does, but
Does it matter? I mean, in the sense that the resignation was, as you say, agreed by everybody else.
yes.
Does it matter why she decided to do it?
My lord, what I say is relevant about why she decided to do it. If one is looking at implication of terms, I say it is relevant that this was a partnership which was in dire financial position. It was making very significant annual losses, and the indebtedness of the partnership was getting ever worse. And I say that the fact that that was a clear and obvious motivation for the claimant leaving the partnership is a very good reason why one would start with the position that she was keen to get out of the partnership. She wasn't interested in seeing whether she could get out any money. She just wanted to get out as quickly as possible. Obviously, if you have what is on the face of it a financially very successful partnership business and you're leaving it, you're much more likely to be interested in seeing whether you can get some financial provision on leaving if you're motivated by the fear of indebtedness to leave. That's far less likely to be on your radar.
Thank you.
And then in terms of just going briefly through the correspondence, what happens after that is page 56. Father writes to Mr. Knowles, who's a trustee, noting that a claimant had resigned from the partnership and didn't think there was anything needing to be done about it. Page 71, we move forward into 2011. And what is apparent in 2011 is that the continuing partners, father and the two sons, are concerned that the departure of the claimant from the partnership may have adverse effects in relation to their relations with NatWest. And they're worried that one partner having left the firm may put that at risk in some way. And so father is requesting in the final 3 paragraphs to ask the claimant to defer her resignation, and he's offering to indemnify her against any claims which might arise. Again, emphasising, I would suggest that the reason why the claimant had left the partnership is because she was worried about the level of its debts and her personal exposure as a result. And that's emphasised again over the page 72, that he won't allow her to suffer personally. page 75, the claimant's response to that on the 29th of August is that she can't unresign from the partnership. She resigned over a year ago, and 3/4 of the way down the page, she's surprised any question of quibbles over the loan, as you told me that the farm assets are more than enough to cover the liabilities. I don't recall any issue when Mum left the partnership. So again, there the focus is on her not wanting to rejoin the partnership. There's no suggestion that she has any interest in making any claim against the partnership for anything. All she's saying there is, well, I think the partnership has got enough assets to cover the liabilities anyway, hasn't it?
Well, she's also saying a bit further up, I can't be in a partnership which does not function as one, which suggests it's not purely financial matters which she's concerned about, but the way in which the partnership was in fact run. She's in London, the farm is in Yorkshire, she's not there in the way that her brothers are, and she obviously feels that she's not, it's not a real, she's not really taking part in the business.
Yeah, she's not. She's not.
No doubt the case.
Yes, she's not and was not participating in the business. Her principal involvement was exposure to increasing liabilities from her perspective. So why would she want to remain in that partnership? So far as the other partners were concerned, they did want, as you can see from this, her to remain in it. First of all, because of their worries that it might in some way unsettle the loan with NatWest, and also because there were various potential tax advantages in having another partner in the partnership.
Well, you say the other partners, and then we've seen what Father said. We don't, I think, have anything specifically from your clients, do we?
Not in terms of the correspondence. I will take you to a note in a moment, which does touch on that. But, there are various meeting notes which they were present. Page 78 then, again triggered by Father's letter, the claimant is writing to her brothers, saying she doesn't know whether they're aware that Father is worried that her resignation from the partnership may upset the overdraft facility, but that she's replied to him, and she's asking them to make sure that the bank is told that she has exited from the partnership last year. And then she's saying she needs to do her tax return, and she would like to sit down to discuss collateral in relation to the partnership loans, as she would like to remove her personal assets from that. Then page 84 is a meeting at which the father and mother and the 3 siblings were present on the 9th of September 2011. This was a note by the first defendant, Procter. As recording, the claimant was insisting she'd resigned with effect from July 2010, and had informed the accountants and all the family. Philip was saying that he hadn't had a letter about that. The claimant was saying that she was willing to have nothing from an ultimate split of the estate. And then she's then recording that she's concerned about her vulnerability.
Who's JAP?
JAP is the mother, my lord.
Thank you.
Concerned about her vulnerability in relation to other assets, in relation to unsecured elements of the loans. Picking up on your point, my lord, complaining there about the fact it doesn't operate as a proper partnership. And then Father, as we've seen from the judgment, explaining why he had set up the partnership, principally for tax reasons, and Mother chiming in relation to income tax.
No, I think JGP must be
James Procter,
Yes.
the younger brother. And then the claimant expressing her view that her resigning from the partnership won't necessarily mean breaking the loan agreement with NatWest. Philip Procter noting that he doesn't think the claimant understands or doesn't want to know the difference between being a partner and having previously charged other assets. And page 85, again continuing that theme, and the claimant wanting to have her assets free from any loan securities. And then there's somewhat ill-tempered exchanges about the fact that she's no longer a partner and to what extent it's her business what the partnership is doing. And then page 87, the second paragraph down, one can see that father is...
I'm just reading 85. Just below the bullet points, not a matter of concern now, she wasn't a partner, said it was because it affected her asset. What asset's being referred to there?
What's being referred to there is that in the complicated land holdings, some of the siblings have direct ownership of bits of the land, and some of the security, in particular for the overdraft, was over bits which the siblings owned personally. So I think that's what's being.
Is that the reference to Spring Hill?
Yes, exactly. Spring Hill Farm, which is outside the area.
Charged to the bank.
Yes.
That is charged to the bank to
Yes.
secure partnership borrowings.
Yeah, exactly. Yes, and
I think that was in the loan agreement, the 565,000 loan agreement, wasn't it?
yes, it refers there to the security. Yes.
You said it was for the overdraft, but I think it was actually security stipulated for by the bank, clause 8 of the loan agreement. First legal charge over 82 acres of land at Spring Hill and Spring Hill Farmhouse.
Yes. I think, my lord, the overdraft also had security as well.
Right.
Yes, sorry, I stopped you going forward.
Sorry, my lord, I was trying to keep up a reasonable pace, but
No, quite.
I may miss the balance sometimes. So effectively, where we've got to here is that the claimant is adamant that she's left the partnership. There is discussion at this meeting about the fact that some of her assets are still subject to security for partnership borrowings, and she is concerned to get that resolved. And she is also expressing her views in relation to the running of the partnership and what it should do, which is causing upset to her brother. And in terms of father's position, one can see at page 87, he is having another go at trying to persuade the claimant to rejoin the partnership. One can see in the second bullet point there, father repeatedly asked the claimant if continuing on would do her any damage. She simply would not answer and simply said that she had resigned last year. And then the next bullet point, the claimant pointed out that mother had resigned and that was okay. We answered by saying that mother's assets, 82 acres, were still charged. And then the fourth bullet point, Philip Procter is saying that the fact the claimant has ceased to be a partner will cause all sorts of problems in relation to tax reliefs, in relation to capital gains tax, holdover and rollover reliefs. And page 88, the top point there, the claimant does not appear to understand that the partnership itself has no assets. The loan is secured by private individuals on some of their property. Those individuals may or may not be a partner. And then during the course of the meeting, the claimant's making various suggestions about letting the farm or selling it. And then...
So your client, Philip's then position was the partnership did not have any assets. Is that right?
Yeah, by that I think one can interpret that meaning not any substantial assets.
Yes. But we now know that it does have a substantial asset, which was the asset that your client successfully asserted in the first round of litigation.
Yes, and it had various other assets as well, obviously the farm machinery and
Yes.
golf club items and things like that.
So is it fair to say that both sides, to the extent that there were then sides, but there clearly now are, in when was this, 2011?
9th of September 11.
Were assuming that the partnership did not have valuable assets? You've shown us that.
Yes, that's the general assumption at this point is that it's a financial partnership that is not in a good financial way.
Yes.
But that it is a partnership that's important to particularly the parents and the two brothers because of its the fact that it's got the borrowing which they need to keep the operation going, but also it's the mechanism which they're using for operating the farming business and the golf club business. And a mechanism
and
which,
to avoid paying any tax if they can get away with it.
which lawfully enables them to take advantage of various tax reliefs,
Yes.
etc. Yes.
Yes.
Then page 93. There's another meeting on the 5th of November. This is again Philip Procter's note. And there one can see items 1 and 2. There's discussion or argument about what capital has been introduced and how the losses have arisen in relation to the partnership. And over the page 94, item 4, capital account. The claimant owes £45,000 to the partnership, must be shown in the accounts as being so, i.e. at year end, she has not paid it back. Would she do so? The claimant indicated not, but mentioned that her rents might pay this off in instalments. So she's declining to repay her negative capital balance, but is raising the possibility that her share of some rental income might potentially be used to pay it off in instalments. And page 96, there's then a letter of 13th of November from the claimant to George Knowles, who was the trustee of some of the trusts. And it's a lengthy letter, but you can see in the final paragraph on page 96, the beginning of that, she's saying that she'd resigned from the partnership on 8th of July 2010. And had resigned because the partnership didn't function as one, and she's giving it as the particular example the fact that she had signed up to the loan agreement of the £565,000, and that was joint and several liability in relation to that. And at the top of page 97, that she'd been asked to rejoin. But had said she wasn't prepared to do that. And the penultimate 2 paragraphs there, she's saying there, as far as she was aware, it was the end of it. She'd asked Philip to tell the bank that she'd resigned. And been told, the bank's been told this week there wasn't any issue, and the annual renewal of the overdraft facility had been approved, so that concern had gone away. And then the accountants have been contacting her about the effective date of her resignation. And then page 98.
I mean, I'm a little bit anxious about us going through this material in such a level of detail. There's a very thorough judgment in this regard, and I mean, I appreciate the point that you're trying to make about the general state of the partnership and so forth, but how are we getting on in relation to getting to the nub of the appeal?
My lord, I can. I'm sorry if I've taken too long on that, my lord, but
well, no, but this process. I appreciate you know this like the back of your hand, but for us, the moving between individual documents, you know, one note by one person, one letter from another person, and so forth. That's not what we're here to do.
yes,
If there's anything in the judgment which doesn't adequately summarise these, by all means, make a point about it. But we don't want to walk the judge's road.
No, my lord. My lord, I was just seeking to show you there the factual circumstances, effectively, of the retirement, and the final document, just for the record, is really the one at page 100, which is the memorandum recording the agreed retirement and the expectation that she will pay the negative capital balance.
Whose memorandum is this?
I think it was drawn up, my lord, effectively on behalf of the continuing partners. I'll put it that way.
Thank you.
And I won't, the reasons we've gone through, take the court through the detail of how the claimant's claim emerged, but effectively, as I say, it started as a denial in her original particulars of claim that she was liable for the negative capital account balance. Moved on after the first trial in the Court of Appeal to a claim that the agreed retirement constituted in law a dissolution, and that she was entitled to a 1/4 share by that route, and is now seeking to claim that she's also entitled to it by way of her implied term. And just to mention one thing, which is in those pleadings, in relation to the position on death, which is picked up then in Mr. Walker's skeleton, the claimant's pleaded case is that the provisions in the partnership agreement concerning death are that on the death of a party, the capital account, whether positive or negative, accrued to the continuing partners. That was her pleaded case. And she subsequently accepted that father's negative capital account had remained the liability for his estate because of various loan notes which father had signed. But her pleaded case remained and remains that on death there's an automatic accruer, which is the contrary of what Mr. Walker is arguing in his current skeleton in relation to that. My lord, turning then in relation to the law and the legal framework, starting with what is retirement, the relevance being in relation to the fact Mr. Walker argues that it amounted to a dissolution. Retirement obviously normally connotes the voluntary departure of a partner from a firm and the continuation of a firm. It's not a defined term in the Partnership Act, although the Act uses and refers to retirement as a concept. And effectively it's an ordinary English word meaning to depart from a concern. It obviously can mean sometimes because of age, but it needn't. And obviously sometimes by partnership agreements, people provide for effectively involuntary retirement, whether at a certain age cut-off point or a deemed retirement in certain circumstances. And secondly, if one considers the circumstances as to how retirement can be affected, again, in my submission, this has been the same both before and after the Partnership Act. And the short answer to it is by agreement. That agreement can be either in advance, ordinarily in the partnership agreement, or alternatively an ad hoc agreement at the time of a retirement, whether before or after the trigger event of departure. And since retirement is a matter of agreement, the partners can agree any terms they like as to the terms of departure. And that need not include any agreement to pay the departing partner anything. And in terms of the authorities, that is clear from Lord Lindley's last edition of partnership law, which was also the last edition prior to the Partnership Act, which is the extract from the 5th edition behind tab 9.1. Of the right to retire, subject to a qualification which will be presently mentioned, a member of an ordinary firm can surrender his share and interest in the firm to his co-partners.
Just a moment. Where are you reading from?
Page 248.
Of the right to retire.
Yes, subject to a qualification which will be presently mentioned.
Yes.
A member of an ordinary firm can surrender his share and interest in the firm to his co-partners or any of them upon any terms to which he and they may all agree. And then pointing out that it must be by agreement. So either you can commonly insert provisions for retirement by agreement into the partnership articles, the partnership agreement. But alternatively, at the end of that paragraph, unless otherwise the departure is by consent of his co-partners, the only alternative is to try to seek a dissolution. And then there's discussion about the particular case of an insolvent partnership. And then 249, general rules as to retiring. Those are the rules which are still set out in the current edition of Lindley and Banks.
So what's the date of the book we're reading from?
This is 1888, so that's the last edition prior to the Partnership Act.
Lindley 1888 and passage on page 249 has not changed.
Correct, yes.
Ever since.
Yes, so you can retire, again, by consent with co-partners at any time and upon any terms, which again includes no payments as a possible part of the agreement. And 3, otherwise you can agree at the time of the retirement, but subject to that you need to see whether you might be able to seek a dissolution. And I don't think I need to take you to it, but behind the next tab is an edition following the Partnership Act, which is in identical terms.
There's been some good research here. Thank you.
Thank you.
So that's just not broken up into bits. It's the same text.
Yes. So the
Yes.
one can, my lord, I can take you to the relevant passage, which is in the authorities bundle on page 243. Paragraph 24.171.
Right, so the date of that is,
This is last year's edition. So the important point there is that retirement can only be by agreement unless you're using dissolution as a mechanism for it, and people can agree whatever terms they want. There are no legal restrictions on what they can agree. So in essence, I say that the position is that where someone retires by agreement, what you have to do is look at the agreement under which they retired.
retires by agreement in circumstances not contemplated by the partnership agreement.
Yes. So, well, if they retire by agreement pursuant to a provision in the partnership agreement, then you look at that
Yes.
agreement in that context. If they've retired under an ad hoc agreement, as in this
Ad hoc
case,
agreement is okay.
yes,
You look at the terms of the ad hoc agreement.
yes. And in the normal way, you look at what they've expressly agreed and whether there's any scope for implying anything else. And the short point in this case is that there was never any agreement that there would be a comprehensive revaluation of all the assets and liabilities and a payout to the claimant based on that. That simply wasn't what anyone agreed or raised at the time.
But the discussion about retirement or ad hoc agreement doesn't proceed on the basis that these were people coming together for the first time. They were people coming together against a background where they had assets and liabilities which were crystallised in the partnership.
Yes.
So that must be taken into account.
Well, as we've seen from the accounts, the position of the financial partnership appeared to everyone to be very bad. And against that background, in my submission, what the position was that the claimant was keen to leave. And it didn't cross anyone's mind to come to any agreement that she would be entitled to a payout, let alone a payout based on an agreement to revalue all of the assets and liabilities. That simply wasn't.
She had an interest in the partnership assets, such as they were.
Yes.
So your case is that impliedly that interest is taken over by her brothers without payment.
Yes, there was no dispute that all of the assets and the liabilities had passed to the continuing partners. That was, I started at the outset showing that was common ground at trial and duly found in the judgment. And
yes, the question is, what impliedly, because nothing was expressly agreed, about the terms on which they took over the assets and liabilities. Your case is, nothing having been expressly agreed, they acquired all the assets without payment.
yes,
And what the judge found was that nothing having been expressly agreed, what was impliedly agreed, is they should pay a fair value for them.
yes. Well, he didn't use the expression fair value, but
But that was effectively,
Yes.
he followed what Mr. Justice Goff did in Sobel and Boston and said, you acquire the outgoing partner's share at a valuation.
yes.
And that's the question for us. Which of those implications is more appropriate, isn't it? I mean, I know you say, well, we have to imply something and nothing should be implied, but the consequence of implying nothing is that the brothers acquire her share in the assets without paying anything for them.
They also obviously acquired at the time the liabilities.
Liabilities.
And so I say in circumstances where the parties at the time regarded the continuing partners as taking responsibility for everything, the assets and the liabilities.
Well, at the time, nobody thought there were valuable assets. But because of your success in the previous round of litigation, it now is apparent that there were valuable assets, or a valuable asset, because we're not concerned with any other assets or liabilities. All we're concerned about is the tenancy. And I think the judge somewhere says the tenancy is a valuable asset, doesn't he? Well, there was evidence.
Yes, there was previous evidence in relation to that. Yes.
Yes. So your case is that because people at the time didn't realise there was a valuable asset, and because nothing was said, your clients acquired her share in a valuable asset without paying for it. I mean, I'm not saying there's anything wrong with that. I'm just saying that is the practical effect of your case.
Yes, in relation to her resignation was by that short letter.
Yes.
That was subsequently the judge found everyone agreed that was to be treated as an agreed retirement.
Well, we've seen the memorandum in which the
Yes.
surviving partners accept that she resigned with effect from that.
Yes, and she did not seek. It was common ground that everyone with effect from that agreement was regarding all of the assets and liabilities as having passed to the continuing partners, so father and the two brothers.
That's
And-
not in dispute.
No.
What's in dispute is whether they have to pay for them.
Yes, and
But- I'm not pushing to you that I think there's anything wrong in your argument. What I'm trying to do is narrow what the actual issue for us is. And I think it's common ground that she left the partnership on a particular day, 8th of July 2010, I think.
yes,
Before then, she had a share in whatever assets there were in the partnership, which was not then, as you showed us, thought by anybody to contain anything of any value, but which we now know there was a valuable asset. And the question is, nothing having been expressly said on either side as to the terms on which the assets and liabilities would pass to the continuing partners, what are the terms which have to be, what are the terms on which the continuing partners acquired her share in the assets?
yes, that's the nub on
That is
the
the issue.
implied terms. Yes.
Well,
There's
isn't that the only issue before us? Are there any other issues?
Well, the other issue is my learned friend says there was a dissolution.
A technical dissolution.
Yes, which
Which the judge says is a matter of semantics, and I'm not sure that I disagree with him. But everybody accepts that she left the firm. Everybody accepts the firm continued with the continuing partners. Whether you describe that as a technical dissolution, it's clearly not a general dissolution because nobody envisaged that the partnership would then be wound up. But whether you call it a technical dissolution or retirement does seem to me to be a matter of semantics, isn't it?
well, yes, my lord. There's the issue of semantics, which I say it's unhelpful to describe it as a technical dissolution because it's not a dissolution as envisaged by the Partnership Act, and it doesn't have the consequences envisaged by the Partnership Act. So what you should call it is what it is, which is a retirement by agreement.
Well, it brings to an end the partnership between the four partners.
Yes, and replaces it with a different one.
Partnership
Yes.
with three partners.
Well,
Partnership is the relationship between parties carrying on business in common. That's what Section 1 says. So before 8 July 2010, there was a partnership consisting of four partners. Afterwards, there was a partnership consisting of three partners. That's clearly a different relationship because the claimant is no longer a party to it.
Yes.
So her relationship with her brothers and father as partners has come to an end. But whether you call that a dissolution or whether you call it a retirement really does seem to me to be a matter of semantics.
Yes, well, my lord, going on the dissolution point, going back to the Act, behind tab 1 of the authorities,
Just before you perform this exercise,
yes,
I haven't yet understood from either point of view why this matters.
well, the pleaded case of the claimant is that although it was a retirement by agreement, as a matter of law, that was a dissolution, and
Well,
she,
I mean, if it's going to be their case that that it's important that it's called a dissolution, well, then we can find out in a moment why it's important. But if you for the moment aren't saying it's important, except that it's wrong, I mean, I can't understand what difference it makes to the issues before us.
well, my lord, perhaps I can say my position very shortly, and then I can, if necessary, respond, which is it's not a dissolution as envisaged by Section 32 to Section 35 of the Partnership Act, and therefore it doesn't have any of the consequences set out in sections 36 to 44
Hold on
in
a second.
terms of an
Not the
entitlement.
dissolution envisaged by 32 to 35. So no consequences as per which numbers?
36 to 44. In terms of it, they, so far as those apply to a dissolution.
Right. Well, did the judge say it had those consequences?
No, but it is part of my learner friends.
Yes, but don't worry
Okay.
about his case. I mean, it's the judgment you've got to worry about. So at the moment, this seems, subject to the submission we're going to hear, to be a bit of a distraction.
Yes, well, my lord, I think it's common ground, at least, that this is not a dissolution as envisaged by section 32 to section 35, and then I say it is clear that therefore the provisions in particular of the provisions in relation to entitlement upon a dissolution as envisaged by the Act do not apply, in particular sections 38, section 39 and section
The judge
44.
did not find that they did.
No, and so I don't see how my learner friend's argument based on dissolution gets anywhere on that, because in terms of semantics, whether you call it a technical dissolution or whether you call it what it was, which was a retirement by agreement, it doesn't engage the provisions of
Well,
section
could we
38, 39, and
address
44.
it on the basis that that if that argument gets anywhere in Mr. Walker's hands, then he will have the right to reply to it.
My lord, yes. My lord, another argument was in relation to that the partnership was a partnership at will, which the judge said he didn't need to engage with. I don't think that argument has been dropped, but again, in my submission, it's clearly not a partnership at will, because the provisions of clauses 3 and 14 make it plain that the circumstances in which the partnership can be determined are in those provisions. That there is, in my submission, it's very clear that there couldn't be a retirement under the provisions of the partnership agreement, because there's no provision that was engaged in the relevant circumstances of the claimant's departure. So the retirement could only have been by way of ad hoc agreement. My learned friend says there wasn't an ad hoc agreement because financial terms weren't agreed. But in my submission, it's plain from what's common ground at trial and in the judgment that there was indeed and had to be an ad hoc agreement for her to retire. The question is, what were the express terms of that and what has to be implied?
Yes.
Now, with regard to my Lord Nugee's question about what should be implied about the terms on which the partnership assets and liabilities passed, which was common ground that they did. In my submission, it's instructive in that regard to look at the provisions, the commentary in Lindley and Banks on partnership in relation to the huge range of possible choices that are open on the retirement or indeed the death without dissolution of a partner in terms of the financial consequences of that. There are two main themes to the commentary in Lindley and Banks in this regard. One is the huge range of choices that are available, and the fact that for different partnerships in different circumstances, and indeed different circumstances of departure, there may be difficult balancing exercises to choose between the interests of continuing partners and the interest of the departing partner or deceased partner's estate. And also that when one comes to the actual event, again, circumstances may be different because something agreed in a partnership agreement in advance may have different consequences as between continuing and departing partners, depending on the particular financial state of the partnership at that time. And my lord, to take you through the relevant paragraphs. Lindley and Banks is behind tab 9 of the authorities bundle.
Yes.
Page 158 it starts. And starting at page 172. Sorry, not one. I beg your pardon, my lord. Page 181. Sorry, my lord.
Yes.
Sorry, my lord. I've slightly dislodged my contact lens, which has left me slightly struggling to.
Would you like it? You've been working hard. Would you like a break of a couple of minutes?
I don't, my lord. I think it would assist if I could.
No,
have
as a
break
contact
couple of
lens wearer, I know how bad it is
Sorry.
when you've not.
I do apologise, my
So
lord.
we'll come back in about 2 or 3 minutes.
Thank you very much.
Court rise.
I use them as well. Do you want me to spotlight it? Let me tell you which part of your eye it's on. Do you want to?
I've got a mirror.
Have a mirror.
Don't know whether this will work. Is that a mirror? Oh, thank you very much indeed. Thank you very much. That's very kind. Sorry. Thank you so much. Fantastic. That was all my see. Thanks. Yeah.
I'm going to come back. Yeah, I've got to get down to Moorgate for quarter past.
I've been there.
Mhm.
Just been there. Not the court.
No,
Are they reading contact?
Hmm?
Are they reading contact?
they're everything. I'm basically as blind as a bat. So.
Impressed that you get read.
It's not flipped inside out so that the rim is high, which means your eyelids pop it over. If the contact lens is inside out and the rim
Oh, I see. No,
is
it's not.
high.
They're hard lens.
Oh, well. Toric.
Court ready?
Yes. I'm extremely grateful to the court. I can now see the court properly again. Well, just dealing with the the question of it being common ground that the assets and liabilities have passed on an agreed retirement. If there had been express agreement concerning such matters, just to emphasise the huge range of choices that would have been available as a matter of principle before turning to circumstances of this partnership. Linley and Banks in tab 9 of the authorities bundle, page 181.
Yes.
There are numerous bases on which the financial entitlement of an outgoing partner can be quantified, but that entitlement will potentially be made up of at least some of the following components. And then there is the range of different options, including capital account balances, current account balances, entitlement in respect of surplus assets, etc. And the question of whether or not there's any entitlement in respect of surplus assets being flagged up as one potentially significant issue. And then going on, I'm not going to read out all of the passages, but just to take you through a flavour of the huge range of choices and the balancing exercise which has to be carried out. The um, 10.331, one of the questions there, whether there is to be an entitlement to a share of surplus assets for the departing partner. Second sentence, in many firms, partners will at the outset decide that the surplus assets should benefit the partners for the time being, so that an outgoing partner will receive no payment on giving up his share of those assets. But in other circumstances, that may be wholly inappropriate. Then 10.333, one can have, even if one's allowing a payment for fixed assets, that can be at a fixed value. 10.337, book or balance sheet value. It is most usual to find that the entitlement of an outgoing partner is determined by reference to a set of partnership accounts drawn up to a certain date, which may fall prior to or after the date on which he ceases to be a partner. And then there are the questions to identify concerning that. 10.338, in relation to construction of the agreement. Although in White, Mr. Justice Park endeavoured to formulate a default rule in favour of market value, his judgment was subsequently overturned by the Court of Appeal, which emphasised it's inappropriate to formulate a general rule on an issue, which ultimately comes down to construction of a specific partnership agreement. This approach has subsequently been re-emphasised by the Court of Appeal in Drake and Harvey and Ham and Ham. 10.339, when formulating his ultimate statement of principle in White, Justice Chadwick referred to family partnerships specifically. Drake and Harvey and Ham made it clear the family relationship to be a highly relevant part of the factual matrix against which the agreement is to be construed. Because obviously, first of all, one's got as factors in relation to that party autonomy in being able to agree what they want concerning the terms of retirement or what's to happen on a death without dissolution. But also the circumstances may vary enormously, particularly when one is balancing the interests of the continuing partners and the departing partner. And obviously in the family context, it's much more likely that there would be an incentive to look after the continuance of the family firm than in a simple commercial context. Then 10.344 on page 186. One of the choices there is to have payments out, if any, based on the last accounts. 10.354, page 188. Obviously, the conduct may also affect what entitlement is at the moment of departure.
So that's where it's all based on the accounts, isn't it?
Yes, well, this is, my lord, my purpose of going through these is just to show the enormous range of choices that there are, which, if one was doing an agreement in advance, and a partnership agreement, or was sitting down and thinking carefully about an ad hoc agreement, the huge range of options that there are in terms of the terms of an exit of a partner, and the terms which one could agree in different circumstances and which with different motivations of different partners are very wide indeed. And obviously one main reason for that is one seeking to balance different interests. One's got the simple element of the balance, which is the larger the payout for a departing partner, the better it might be for them or for their estate. But that's, on the face of it, to the severe detriment of the continuing partners, particularly if you've got a partnership which has a capital asset that is vital for the ongoing partnership business and no ready funds.
How much is the dispute about in this case? I mean, there is the valuation to be made, but what's the dispute about?
But I think
in
at
financial terms?
one stage the claimant was putting her claim in relation to it at 173,000.
Would that being a quarter, I beg your pardon? Would that being
Yes.
a quarter share of the tenancy value?
Yes, because there was an earlier valuation report, but it was not on the same assumptions as
Right,
the
so
judges
at the
ordered.
highest level, 173,000. I mean,
Well,
that
I don't-
being how she puts it.
I don't think the claimant would say it was the highest level. That's what she previously put it at.
Previously, okay. And the costs of all this? Anybody
Well, my lord, as
added those up?
my lord, as the judges observed, the parties sadly have been
I
locked
know,
in
but
this.
I mean, these reality checks are, you can't have too many of them.
No.
What were the costs of this limb of the trial? Meaning the hearing before the judge leading to this appeal.
Well, my lord, I don't think there is any statement of what those are.
Right. Well, after today, the parties will please provide us with a single page on which the costs of the proceedings leading to the second judgment. Forget the previous proceedings. The limb of the proceedings leading to the second judgment. Round figure costs, please, on both sides on a single page, up to and including this appeal itemised at the various stages of the proceedings, trial, appeal. Okay.
And then 367. Which is on page 192. Noting that in some previous editions, the editor had suggested that there may be effectively a default business where a default assumption where the agreement is silent on the entitlement of an outgoing partner, but recognising that in the face of the three Court of Appeal decisions, re White, Drake and Harvey, and Ham and Ham, that's not possible, and that one can't approach it with any presumptions as to what.
Could you
party's
just
partner.
give the paragraph reference again?
10367 on page
367. Thank you very much.
And then emphasising that in particular the question of whether any unrealised capital profits are something which a departing partner, whether by agreed retirement or death agreed without dissolution, is entirely dependent upon what people agree, and that one can't approach it with any presumptions. And then if the parties are considering that question, and the question of revaluation, 10378, which is on page 116. It's already been seen that when construing partnership agreements, there is no room for any presumption or leaning in favour of assets being revalued when a partner dies or otherwise leaves the firm. And recognition of this, partners may decide to include an express revaluation provision in their agreement with a view to ensuring that the outgoing partner is credited with his full share of the asset surpluses, or if the assets have decreased in value, debited with his share of any deficit. Such provisions, which have much to commend them in terms of fairness, were common in years past, but are now encountered less frequently, particularly in the professional sphere. This perhaps reflects a concern to limit the financial burden undertaken by the remaining partners, which can become insupportable in the event of a succession of voluntary retirements, or where the partnership assets are valuable but illiquid, e.g. farmland, so that their payment out at full value to an outgoing partner might entail a sale of those assets and spell the end of the partnership business. So, my lord, that's really emphasising that if one is in the position of agreeing a retirement or agreeing non-dissolution on death, whether one's agreeing it in advance in a partnership agreement or at the time, there are a huge range of different options and balances open to the parties. And in my submission, if the parties have, as they did in this case, reached an agreement where the assets and the liabilities are passing to the continuing partners, and the question arises as to whether implicitly the departing partner is entitled to a payment from the continuing partners, and if so, on what basis that payment is to be ascertained. One has to face the reality when a term is being sought to be implied, that even before one gets onto the facts of the particular partnership, there are so many different choices that would have been open to the parties had they sat down and discussed it, that one can't draw any implication that it's obvious or necessary for business efficacy, even as a matter of principle, that they should be paid out, the departing partner or the deceased estate should be paid out based on a full revaluation of all of the assets and an entitlement to a share of unrealised capital profits, amongst other things. That is something which, if parties want to agree that on retirement or on death, then they have to sit down and discuss and agree it. Because the court can't say that one method of payment out or a different method is the one that is necessary for business efficacy or the obvious answer. If parties want to agree a payment at the time of retirement or death, they need to agree it.
Isn't the starting point to consider what the legal rights of the parties were immediately before, in the instant immediately before the dissolution or the retirement, sorry.
Yes.
Better put it. This seems to turn upon you saying that they need to imply a term, whereas the counter-argument would be that you need to imply a term, which is a term that rights were surrendered. I mean, as my lord has said, this all arises because the perception of what was in the partnership has changed since that date. But I mean, your ground of appeal proceeds on a contested premise. The contested premise being that they need to imply a term. You see what I mean?
Well, my lord, the
alternative is that if you're going to be relieved of the obligation to pay for the asset that you're acquiring on the retirement, namely taking over the whole partnership without any payment for it, then the onus is on you.
Well, my lord, that's why I started at the beginning by saying what was common ground and what the judge had held, which included the fact that the partnership assets and liabilities had passed to the continuing partners in
Yes,
with effect from.
That begs the question: is on what terms? That's what you've been helping us to consider. The judge made no finding. Obviously, he didn't, because he reached a contrary conclusion that they passed free and gratis to your clients.
Well, my lord, if one takes it in stages, it's common ground, and the judge so held that the assets and the liabilities had passed. And one could stop there with the agreement. I don't need to go any further than that, because that is a passing as a package of all of the liabilities of the partnership, including the NatWest loan and the overdraft and everything else, to my clients, and they also get the assets. There's no reason why that can't be an agreement in itself, full stop. It's a following question as to whether you also need to imply any term as to payment or otherwise.
Or imply a term that accrued rights within the partnership were surrendered, to put the same thing a different way, but to a different.
Well, my lord, in my submission, that's inherent in it being common ground and held that the assets and liabilities have passed. That includes, my lord, in terms of, we haven't got the authority because it's this was common ground and not on appeal from the judgment, but in it's referred to in Blackett Ord, which is behind tab 8, paragraph 16.37. The case of Gray and Smith. Sorry, page 148 of the. So there was an agreement that someone was going to withdraw from a partnership, and in that case there was provision for express payment of some sums by instalments, and it was held that two things were implicit in the agreement to withdraw. First, that the withdrawing partner should make over to the continuing partners all his interests in the partnership and the partnership assets. And secondly, the continuing partner shall indemnify the retiring partner against all the liabilities of the firm from that time forth. And so that there's no dispute that that's what's happened. That's what the judge held, and it was common ground that that's what had happened. But the question is whether, in the circumstances of this case, it's then also right to imply into the agreement for retiring the contended implied term, which is that the claimant is entitled to be paid out on the basis of a full revaluation of assets and liabilities. And I say before you get to the particular facts of this case, one can't imply a term of that kind because of the sheer range of choices that are open to partners who are in principle agreeing terms of retirement or departure. It's impossible to say that one is the obvious, even as a matter of principle, the obvious or the necessary outcome. Because the reason why White and Drake and Harvey and Ham and Ham say that one shouldn't approach construing a written agreement concerning retirement terms or terms on death with any presumptions or default rules is because of that huge range of options and the fact that what may be appropriate for different partnerships in different circumstances and by reference to the perceptions of different partners can vary so widely.
But isn't that just a reflection of the fact that the express terms of partnership agreements vary very significantly.
Yes. But
So, and it maybe confirms that the starting point needs to be the partnership agreement.
my lady, yes, but in a case where, as here, the departure is by an ad hoc agreement, I say likewise one has to start
It's
with.
in the my point is, it's always going to be in the context of the existing partnership agreement.
Yes.
So one might think one would look at that, even if it doesn't directly cover this situation.
Well, my lady, what I say in that regard is 2 points of particular relevance are, as we've seen, the original partnership agreement sought to keep control in the hands of the senior partners, mother and father. So it was they who were able to serve a notice of dissolution, contractual notice, and they who were able to serve notices complaining of default. So there was no power for effectively a junior partner to break up the partnership, other than by, if any availability was under the provisions of the Partnership Act for seeking a dissolution.
The father could have insisted that the claimant remain a partner because she had no unilateral right to retire.
Yes.
And we saw that in Lindy, right back in 1888.
Yes.
Unless the other partners agree, you can't unilaterally withdraw from a partnership.
Yes.
So it was in the father's hands, but he took the view, no doubt he didn't take advice on it, that she was entitled to retire. So he didn't stand in her way, although he tried to persuade her to unretire. And your clients, the junior partners, went along with that, and it was accepted by everybody that she did retire. So I don't myself see that you get much assistance from the fact that the father was intended to have to call the shots, in the claimant's words.
Well, my lord,
how does that help us assist? What were the terms on which she left?
well, my lord, if one's implying terms into the circumstances in which she left and it was agreed she was going by retirement, if one asks oneself, would father have said the same thing if the claimant had said, I would like to retire, but my terms of retirement are that there's a full revaluation of all of the assets and liabilities, and I'm paid out my share based on that, including if there are valuable property assets. Would his answer have been, of course, or obviously, or would his answer have been, no? That would be terrible for the partnership. We don't want to be doing that. Thank you very much.
Well, it's a slightly unrealistic question because nobody realised there were valuable assets in the partnership. That. What you showed us earlier, as I said before, was that everybody was proceeding on the assumption that the partnership was just a basket of liabilities. So it's not surprising she wanted to leave, and it's not surprising that the others were resistant to it. But she did leave. That is a fact. That's common ground. The judge has found it as a fact. If she'd said to father, I want to leave and I'll take whatever legal consequences naturally flow from that, it's far less obvious that he would have said, no, you can't do that. And that is the question that's facing us. What are the natural legal consequences that flow from the fact that someone retires from a partnership when nothing is expressly agreed about the terms on which the assets and liabilities pass to the surviving, continuing partners, which, as you say, is common ground. And that, I think, is the question and what we need to concentrate on. What is the default position?
Well, my lord, in my submission, it's not appropriate to have a default position because what you should look at is the particular circumstances of the particular retirement.
Is there a starting point, if that's a better?
Well, my lord, I say the starting point is what has been agreed, and
Yes, but we know nothing has been agreed. That's the point. We know that nothing has been agreed about this.
well, my lord, I say what has been agreed is that she is retiring from the partnership,
Yes.
and I say it's implicit in that as per it was common ground at trial and per Gray and Smith, it's implicit in that the assets and liabilities pass, because that is the nature of the retirement.
Well, what Blackett Ord actually says is the retirement of a partner almost always involves the sale of his share to the continuing partners.
Well, yes, my lord, almost always means there's no reason why you particularly have to have a sale. And there are lots of examples where you might not wish to have a sale. So one example is where the partnership is in bad financial position and someone just wants to get out. Another example might be a different kind of family partnership where the older members of the partnership want to effectively retire and leave the partnership, but have enough money of their own, don't want to take out any money, they'd rather leave it in there. Another circumstance might be where someone wants to rapidly leave a partnership in a hurry for other than financial reasons. So, for instance, a politician who's in a partnership that's become politically toxic by association and he just wants to leave, is not interested in his money. There might be a rich godfather who's helped set up a partnership with a godchild and has been involved to give it status to begin with, but is then happy to leave, but doesn't want any money out.
So, just so I'm clear, I've understood. Your submission is the act of retiring, which is assented to by the other partners or accepted by the other partners, implicitly involves an act of transferring your interest in the partnership assets to the ongoing partners.
Yes, as per the 1888 Lindley wording, can surrender his share in the partnership on whatever terms they wish.
And that if nothing is said about those terms, then however valuable that share is, the outgoing partner gets nothing. That's your submission, is it?
Because it depends upon what is
Yes,
agreed.
but we know
yes.
nothing is agreed. So that a mere retirement, which is assented to, has the effect of transferring your share in the asset to the continuing partners for no payment. That's, I mean, if you want a payment, you have to stipulate for it. That's.
Well, in terms of payment, my lord, there are two aspects to it, because by transferring the assets and the liabilities, unless the assets and the liabilities happen to be precisely equal, there's an element of consideration passing one way or the other, even at that point. But in terms of an active payment out by the continuing partners, in my submission, that entirely depends upon whether they have chosen to agree that there should be any such payment or not. And if one is looking beyond
If she was going to be indemnified against ongoing liabilities, why does she have to pay 40,000 into the firm?
Well, my lord, in relation to that, she agreed to pay that in the end.
Well, in the end, but at that stage, by the time she agreed to pay it, her email says, but of course you have to take account of the Agricultural Holdings Act tenancy. So it's not an agreement to pay it and that's it. It's an agreement to pay it subject to my claims.
Well, in terms of the way in which that negative capital account was paid and claimed and paid, you saw in the documents that she was asked to pay it, and the answer was effectively
yes,
no.
But I'm trying to understand on what basis she was asked to pay it, on your submission as to what happened when she left. Because your submission as to what happened when she left was that the assets, her share in the assets passed to the other partners, her share in the liabilities passed to the other partners. Obviously that can't affect the right of any creditor to pursue her, so the bank could still come after her. So it must, as Mr. Justice Kekovich says in Gray and Smith, have taken the form of an implicit indemnity by the ongoing partners against her liabilities, together with an agreement that she shouldn't be liable for any debts post-leaving. So on what basis did your clients claim that she nevertheless had to put 40,000 into the firm because she no longer has any interest in the assets and she no longer has any responsibility for the liabilities? Why is she being asked to pay 45,000?
The basis on which she it was claimed that it was on the basis that had been the understanding that she would be paying it.
What understanding? What understanding? Where from?
Well,
Nothing was agreed.
No, my lord, she denied that was the case. But then, shortly prior to the 2018 trial, her solicitors wrote a letter, which is, I don't need to take you to it, but it's, or perhaps I should take you to it in relation to this question. It's in the end of Supplemental Bundle 1, page 103.
Yes. It's our client's capital account deficit. For similar reasons, our client accepts that she is liable for a sum of 42,000, subject to the same possible adjustments. And the adjustments are, if you look at the previous paragraph, any adjustments required to reflect the outcome in these proceedings of, among other things, your client's HHJ claim. So it's not, I accept I have to pay you 45,000 and that's that. It's, I accept I have to pay 45,000, subject to adjustments in respect of your claims to a valuable tenancy.
Yes.
But put that aside, because that's much later. This is 2018. What I'm interested in is on what basis, on the way in which you've been addressing us, which is that she walked away, she left behind the assets and the liabilities, and that is that. On what basis was she liable to pay £42,000 into the firm?
Well, as I say, the claims base.
45,000 into the firm.
Yes. And my lord, can I just remind the court as well that was, of course, based on book values in the partnership accounts.
So not only does she lose any interest she has in the assets, which nobody knew about, but she has, and she gets an indemnity, as I think you've accepted, for all the liabilities, but she has to pay 45,000 based on book values, although there aren't any actual liabilities of hers that's referable to. Is that
Well, my lord, in relation to that, one can see that the in the documents one we're looking at, she was asked to pay that, and the basis of the claim was that it had been understood that she would be paying it. One can see that there was the talk in that meeting about she might be offsetting her rents against it, etc. So effectively, it was on the basis that there was a common understanding or agreement to the effect that she would be paying it. She denied that. That was never tried out because she agreed to pay it and did pay it.
Yep.
But that was a settlement that was based on the book value deficit. It was not based upon an attempt to revalue the assets of the partnership and see whether capitalised works that have been spent were actually worth the money that had been spent to carry out those various improvements and other works.
okay? Thank you.
So,
Right, how are you getting on?
Well, my lord, I think that's although I've gone slightly out of course, that's probably some of the main points on the implication of terms that they're.
Good. Do you want to look at the judgment at any point on this, or?
Well, my lord, I should address you on a couple of aspects of that. The obviously the judge, you'll have seen from the judgment at page 136 of the core bundle, 240.
Yes.
Placed a lot of emphasis on Sobel and Boston. So I should take you to that. It's in tab 2 of the authorities, page 14. This was the facts were that there'd been a partnership between people in practice as solicitors. One of them who'd been accused of criminal offences had left, and he then subsequently, as he admitted, partly as a way of hoping to put some pressure on them, applied for the appointment of a receiver manager and claimed that there had been effectively an agreement to dissolve the partnership, and that he was therefore entitled to.
We've got all this within the judgment, have we? The relevant parts. Should we
Well,
get? and the judge devotes a page to this. Do you want us to go to the judgment itself in Sobel? Or?
Well, effectively, in the judgment, my lord, at paragraph page 136 of the core bundle,
Yes.
paragraph 240,
Yes.
the judge considered the matter was clearly dealt with by the decision in Sobel. And then 242 and 243, he set out parts of the judgment in Sobel.
Yes.
And then 244 said, I need not discuss the jurisprudential basis of the result, but it appears to me that it is based upon an implied contract or implied contractual term. My lord, in relation to the points I would make concerning Sobel, firstly, if one looks at the account of the facts,
Yes.
there is no reference to any partnership agreement or any duration of the partnership. And so I would submit that it is likely that what was being dealt with there was a partnership at will between those people. And if that's right, then to say that whether there's a retirement or a dissolution, each of those partners would be entitled to a full share of the assets is a very unsurprising conclusion, because that would follow from the nature of a partnership at will being determined by whether it's retirement or dissolution under the provisions of the Act. So in terms of the actual conclusion on the case, that would not be surprising. If one goes beyond that to say, is Sobel and Boston authority or reliable authority as at today, for a conclusion that one should imply a term, that if there is an agreement to retire without agreeing terms, the retiring partner is by implication entitled to the value of his share at the date of his retirement, my submission that would not be good as a proposition of general law for two reasons. Firstly, it predates the decisions in White and Drake and Harvey and Ham, which emphasise that one shouldn't approach terms of departure with any preconceptions or presumptions or default rules about the entitlement of a partner who's retiring by agreement or the deceased's estate. So those cases subsequent to this one, in my submission, would be entirely inconsistent with an approach that if there's an agreement to retire and no provision as to the financial terms, that one should have then a default presumption or default rule that one is entitled to be paid out at a full valuation. And the third related point to that is the passage which in Sobel on page 18, page 1591 of the judgment, the top, which was cited from Lindian on partnership, the 13th edition, was focused on the question that was really live on this motion, which is whether it was appropriate to have a sale of the partnership assets and liabilities, or alternatively a payment out. But the law at this time under Sobel and Boston remained as it had been, as we saw in the old editions of Lindley, namely that the question of the terms on which people leave a partnership by retirement depends upon the terms that they agree, and it's up to them what they agree. So there's no preconception or starting point beyond what they agree at the relevant time of retirement. And behind tab 9.3, we've got here the extracts from the 13th edition of Lindley. And one can see that the editors at that time are not suggesting anything different in relation to the general law governing retirement. So at
Give me the page reference again,
page
please.
254, my lord.
Thank you.
Retiring from the firm in the absence of a special provision, that's in the partnership articles agreement, enabling a partner to retire, there is no method by which he can do so without a general dissolution and winding up the firm, unless, of course, some agreement can be made between all the partners at the time of retirement. And so therefore, in this chapter here about terms of partnership articles, there are all sorts of suggestions about different terms one might agree. But then on page 270, one has the same general rules that have remained in place throughout. Namely, that it's competent for a partner to retire with consent of partners at any time and upon any terms. Otherwise, they may have to look to dissolution. So I say that Sobel and Boston, if the inference that from the lack of any discussion of a partnership agreement that it was a partnership at will is right, then it would have followed whether there was a retirement or a dissolution that the firm would have been determined, because that's the nature of a partnership at will. And therefore, each of those partners would have been entitled to their full share of the assets and liabilities. But it does not follow that that should be the default rule which applies to any retirement from a partnership. If there's a retirement from a partnership and there is no agreement as to what financial payment, if any, should be made, one cannot, as a default rule, infer that the answer to that is that there must be a payment out at full value based on a revaluation of all of the assets and an assessment of liabilities as if there'd been a sale. Because if you try to apply a default rule of that kind, you run up against all of the reasoning in White and Drake and Harvey and Ham as to why that's not appropriate. Because the circumstances of partnerships vary so much, and the circumstances in which people may choose to retire vary so much. It's inappropriate to have a default assumption about that. If on the particular facts, it's appropriate to imply something, well, that depends on looking at the particular facts, but you can't approach it by saying, as the judge did, this is just a default rule that will be applied unless they agree something expressly to the contrary, which is effectively what the judge did.
So would it be right to say he effectively got the burden wrong?
Yes, he got the burden wrong, and he approached it in the wrong way as a result, because he was assuming that was a default rule, effectively, that applied. What he was not looking at is the circumstances of this case and seeing whether it was appropriate to imply, as a matter of business efficacy, or being so obvious as to go without saying, that it was implicit on the claimant's retirement that there would have to be a full revaluation of all of the assets, and then a distribution one way or the other based on that. And I say if he had asked that, if he put the burden the right way around and he'd asked the correct question, in my submission he wouldn't have concluded that it was right to imply a term in the terms that he did, because if one looked at the facts surrounding the partnership and the family dynamics, in terms of the position of the continuing partners, obviously, if one takes the particular example of the tenancy, that's obviously of vital importance to the ongoing farming operations. It's something with a potentially large capital value. And in circumstances where the partnership was in the financial state one could see at the time, and the claimant was anxious to leave because she did not want to be associated with the increasing liabilities, particularly with concerns about her own personal assets, such as her London house, etc. If one asks, balancing the interests of the different people in that situation, whether it was necessary for business efficacy or so obvious as to go without saying that she should be paid out at a full valuation of everything, in my circumstances, the answer to that would be no, it's not appropriate to imply a term on that basis. And that's underlined by what was what happened in relation to the issue of the negative capital balance that my Lord Nugee was asking about, because what the continuing partners asked for was that they weren't seeking to have a revaluation of the assets that were on the accounts. They were just asking for what was there in the books, and the claimant's response was to resist that. And that emphasises 2 points really. That one, there was an unwillingness on the claimant's part to really do any further settling up in relation to the exit of the partnership financially, one way or the other. She just wanted out, and that to be the end of the matter. She wasn't asking for any payment to herself, and such discussions as they were based solely on the book values in the partnership accounts. No one raised the question of there being any kind of looking at what the actual assets were and their values at the time. There was no question of even starting that process, let alone any discussion of getting local agricultural valuers or anyone else involved. So in my submission, that just underlines that in the circumstances of this particular exit, it was just the departing partner was keen to be gone as soon as possible. There was no interest in her part on any kind of financial settlement beyond being free of the ongoing liabilities, and she was perfectly content with that at the time. And subsequently, obviously, she now wants to revisit the position and say, well, I now know that there's a valuable asset there, a valuable asset whose existence I was denying for years, but now that it's there, I want to revisit the retirement agreement, and I want to have, in relation to that one asset, a payout based at its full value. But there's no suggestion still from her about, as it were, how that sits with the fact that her payment in towards the liabilities was based solely on the book values without any kind of revaluation.
Yes.
And it, as per the, in my submission, really, the Procter and Harding case, which has been referred to, where Lord Justice Longmore says, effectively, if there's a retirement by agreement, that's the time to agree any financial terms. If you don't, it's going to be very difficult to try and imply financial terms afterwards. And in my submission, Lord Justice Longmore was that's really the nub of the point, that the parties here were quite content to effectively have the claimant leaving, getting rid of her liabilities, passing over the assets as a bundle. She had no interest beyond that at that time. Effectively, what she's now seeking to do is to come back to revisit that bargain and say, oh, actually, if I had known that there was another asset, or the value of one of the assets was more than I thought, I would have asked for specific terms and payment. But that's revisiting her bargain, and that doesn't support her claim to imply a term as at the circumstances in 2010. Because if the court was adopting an approach per the judge of saying effectively there's a default rule, given the huge variability of partnerships and the circumstances in which people leave partnerships, that would have the potential to have very significant adverse effects on all sorts of departures. And that's why in White and Drake and Harvey and Ham, they said they don't have any default rules, but effectively having a sort of standard implication that if you leave and are silent about financial terms, that there's a default implication you will be paid out at a full value, is cutting directly through the reasoning of those cases. Because it's causing exactly the problems which they identified. Is you've got to look at particular circumstances, particular balances. You don't have a default assumption.
Well, I think you would say the default assumption is if you don't agree on anything, then you don't get anything.
Yes, you get what you agree, and if you don't agree that there's to be any payment to the departing person or the estate of a deceased estate, that's it. And my lord, I outlined some examples as to circumstances in which that would be very unsurprising. That's why I say the court needs, in each case where there's a claim to an implied right to a payment, to look at the particular facts of the case. Because as per the passages in Lindy and Banks about all the different kinds of terms people can agree, obviously you're always balancing the departing and the continuing against the dynamics of what the background is.
Well, I have to say, speaking for myself, I'm a bit unhappy about the idea that whether you get anything if you haven't agreed on anything depends on all the facts and a close factual investigation of what people might or might not have thought or believed at the time. I think both your cases really come down to what are the consequences if you agree to retire, but you don't say anything about the financial consequences. Your cases, if you don't agree on anything, you don't get anything. In their cases, if you don't agree on anything, it's implicit that the people who take over the assets and liabilities have to pay the fair share of the assets and liabilities they take over, and that requires a revaluation. That seems to me to be the difference between you and what we have to decide. And I would not think the answer is, well, it all depends on what the particular type of partnership was and what the particular assets were and what people might or might not have thought at the time.
What I really meant by that, my lord, was that there might be something particular in the facts which suggested it was right to make a particular implication. So something short of a precise agreement, but enough to make it clear to the court that it was obvious that what the parties intended. And on the Sobel facts, it was clear that although there was an agreement to retire, that was on the basis that there would be, quotes, a proper financial settlement in due course. And I say if you combine that with the fact that it appears to have been a partnership at will, it's wholly unsurprising that the judge focused on the question of whether it should be sale or retirement. Should have concluded, well, in any event, if it's retirement, that would be the financial entitlement, because that follows from the nature of that kind of partnership.
Yes.
I think you further say that the 45,000 that you pray as showing that was likely to be what the parties intended to be the settling up.
Yeah, yes, in the sense that is what, if one looks at the actual discussions at the time, that's what the continuing partners asked for.
Yes, but in the sense that the fact that they insisted upon that provision, albeit with a proviso that it could be treated as a loan rather than actually paid up, that suggests, you say, that was the settling up on the conclusion of this partnership.
Well, in relation to that, my lord, that I say,
I thought that was what you were putting that in for.
Well, my lord, that's what they asked for. The claimant denied.
Well, I know she
that
did.
She was
in the end,
Yeah.
the memo says that it was agreed that she would be responsible for it in one way or another.
Well, in the context of the litigation, she eventually agreed to pay it. But that
is 2011.
I don't. Yeah,
I don't think she wasn't a party
She
to that.
didn't agree to that. I think is.
My lady, yes, it was.
Oh, I'm sorry.
That was
I'm
recorded.
sorry, I misunderstood that memo. I thought that was an everybody memo.
That was what the continuing partners recorded, but the per the meetings, one can see that the claimant was resisting being liable for that, although was saying.
Because you took it to me, it took us to it at the end of that sequence.
Yes.
I sort of assumed that that's where everybody had got to, namely, I'll pay it, but I may not pay it. Anyhow, let's. Have you now concluded? Or would you like 5 minutes after the break to do so?
Well, Lord, I suspect I can deal with matters by way of reply rather than.
Well, I just know that when, you know, I don't want you to suffer from esprit d'escalier and realise that there was something important you wanted to say, simply because we got to the lunch hour. So, subject to anything that does occur to you,
Yes.
are those your submissions?
Yes, my Lord, on the basis that I think from the indications I don't need to deal, as it were, with the dissolution issue.
All right. Good. Well, we'll start again at 2:05.